Good morning, students. Today we will continue our session the, with the previous session. We'll continue our previous session that was dealing with case laws under the European Convention on Human Rights. Okay, and in this session also we will be dealing with three case laws under the European Convention on Human Rights. Now, the first case in this regard that we will be dealing is Sunday Times versus United Kingdom. Now, in this case, what happened was that there was a drug that is by the name of thalidomide. Okay, now this thalidomide drug was manufactured by a company known as distillers. Okay, now this drug between 1958 to 1961, it was circulated and it was prescribed as a sedative for pregnant women. Okay, but this drug had side effects. Okay, and because of this drug, okay, the women who took this drug during their pregnancy, okay, afterwards they gave birth to children who suffered from deformities. Now, um, around 70 children who were born with deformities, their parents, they the parents of these deformed children, they filed a case against the company, that is distillers, who had who were manufacturing this drugs. Okay, by the end of 1971, there were around 389 claims that had been filed against the company. Some of these claims were settled, some of these claims were not settled. Okay, so now, while the actions which were filed against the company, they were being litigated, okay, there were also newspaper articles and reports that were published regarding these drugs and the birth defects that had been caused due to these drugs. One of the prominent publisher, which was the Sunday Times, okay, it also came out with an article by the name of "Are Thalidomide Children a Cause for National Shame?" Okay, in this article, the Sunday Times had discussed the settlements, okay, that were being negotiated and by the company, okay, as to provide compensation, and it characterized the offers in that settlement as being grotesquely out of proportion to the injuries suffered. That means it the according to the Sunday Times, according to the article published in the Sunday Times, the settlement that was being offered by the company, it was of a very meager amount and not proportionate to the harm that had been suffered, okay, by the people, okay, who had taken the drugs, that is thalidomide. Now, it also, the article also criticized the English law on the subject, okay, regarding recovery and assessment of damages. Okay, now it further said in a footnote that it will again come up with an article to, that will be dealing in a greater depth with the cause of the birth defects because of the drug thalidomide. Now, while the publication had come, the company that manufactured this drug thalidomide, that is distillers, it went to the House of Lords. Okay, first it went to the lower courts, and then the Sunday Times appealed, and then finally the case went to the House of Lords, where the House of Lords, it granted an injunction. Okay, saying that if the article that was to be published, that the that the previous article published by Sunday Times had declared in its footnote that it will be publishing another article that would be dealing with this case in greater depth. Now, if that article was to be published, it gave an injunction prohibiting its publication, restraining its publication, and told that if it was published by Sunday Times, it would constitute a contempt of court. Now, this was held by the House of Lords on the ground that the newspaper was attempting to put pressure on a litigant, okay, in a case which is pending in the court. Now, therefore, and that it is contempt of the court to publish materials which prejudges or is likely to cause public prejudgment of the issues raised in pending litigation. The first, the ground that deals with putting pressure on a litigant, and that is called the pressure principle. And the second ground is called the public prejudgment principle or the prejudgment principle. Now you can very well relate to this to uh, almost the frequent happening or the that takes place, the frequent happenings that take place when any important or controversial issue or a controversial case, it goes before the court. The media tends to highlight that case too much. It tries to cover that case. It publishes articles on that case, and that information that the media provides and the discussions that take place in the media, okay, about the case, about the persons who are concerned in the case, okay, that basically it we see that it kinds of puts pressure on the litigant, okay, and it also causes the you know uh, the public to to judge the case, to have a certain notion in their mind before the court has actually pronounced its judgment, okay. Now this is also this is what we nowadays called as media trial, okay. So this also is an entrance to the justice, okay. A party is gets unwanted attention, and it has to then justify, and it's seen as as an accused even before the court has pronounced him or her or the company or anybody who's concerned in the case as who is the accused as an accused. So on this ground only that it interferes with the the right to it interferes with the administration of justice. On this ground it held that the articles will it granted an injunction restraining the publication of the articles. Now after this the case, the Sunday Times approached the European Court of Human Rights, saying that this was in violation of Article 10 of the convention, okay. Now Article 10 of the convention, it reads as uh, everyone has the right to freedom of expression. This right shall include freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. So, this article is in the first para, it is granting this right of expression to everybody. Okay. And then it says that this right shall not only include freedom to hold opinions, but to also receive as well as impart. That means to give information and ideas without interference by public authority and regardless of frontiers. In the second para, this article says that this freedom of expression may be subject to such formalities, conditions, restrictions, or penalties as are prescribed by law and are necessary in a democratic society. So we have already seen the Handicide case. Okay. And in that case also Article 10 was involved. So we already know what is the content and the meaning of being prescribed by law. Okay, and we also know that the conditions on which restrictions or regulations can be imposed uh, on this freedom, that is freedom to expression, they have to be constituted very strictly. Okay. Now it says further, as a prescribed by law and are necessary in a democratic society. So we have already seen in the Handyside case that it should be necessary in the interest of a democratic society. Okay. And then the other terms are in the interest of national security, territorial integrity or public safety, for the prevention of disorder crime, for the protection of health or morals, for the protection of the reputation or right of others, for the for preventing the disclosure of information received in confidence, and what is of particular importance to our case means particular importance in this case, okay, is the ground for or for maintaining the authority and impartiality of the judiciary. Okay. So of course, according to the House of Lords, applying the pressure principle and the prejudgment principle, the article published by Sunday Times and the further article that was going to be published, okay, it was affecting the impartiality of the judiciary, and it was the injunction was also necessary to maintain the authority of the judiciary. So we have seen what Article 10 reads. Now we will come to the court's reasoning. Okay. Now the applicant, it had informed that the argument of the applicant was that the law of the contempt, okay, was so vague and uncertain, and the principles initiated by this by that decision, okay, that decision of the House of Lords was so novel that restraint imposed could not be regarded as prescribed by law. So the basically what the applicants were arguing was that, you know, that the content of, you know, contempt of court, okay, it was very vague and uncertain. Okay. And because of this, and the principles initiated in that case, they were so novel, okay, that because of the uncertainness involved, and because of the novelness of the principles involved, okay, they cannot be regarded as being restraints as prescribed by law. Okay. Now, taking up this argument, the court, it observed that the word law, okay, that is mentioned in the expression prescribed by law, it covers not only statute law but also unwritten law. Now, unwritten law here is being referred to the common law. Okay, we know that the contempt of court, it was it had its root and was formed by the common law. Okay, so if the common law is not being, or the unwritten law, which is the common law, is not uh, covered within the term law, okay, as used in prescribed by law, as used in the expression prescribed by law, then what will happen is that all the countries which have, a common law uh, legal system, they will suffer. Okay, and it will hit out at the very root of the legal systems of these countries. Okay, so therefore, it said that the court, it observed that the expression law, the word law used in the expression prescribed by law, it covers not only the statute law but also the common law. Okay, that means unwritten law. Okay, and it told that there are two requirements. Okay, that flow from the expression prescribed by law. The first is that the law must be adequately accessible, and the second is that a norm cannot be regarded as law. Now, a norm is not a law. Okay, what do we understand by a norm is a norm is you know um, a norm is a rule of behavior. Okay, a rule of behavior or conduct. Okay, uh, that we are expected to abide by. Okay, or we are it's the acceptable conduct in a society. Okay, so we have to conduct ourselves according to the norms of the society. Okay, a certain practice that is deemed as acceptable. Okay, a certain certain behavior that is acceptable to the society. But this is norm is not a law. That means if suppose there is a particular norm, okay, that uh, says that according to which you have to uh, conduct yourself in a given situation within the society, okay, or according to which you have to conduct yourself, that that norm is the that conduct is the acceptable conduct in the society. Now even if you deviate from it, okay, you cannot be prosecuted uh, you know for the violation of a norm. You cannot be prosecuted for violating it. Okay, you can only be prosecuted if you have violated a law. Okay, so therefore the court says that a norm cannot be regarded as law. Okay, the law must be formulated with sufficient precision to enable citizens to regulate his conduct by being able to foresee what is reasonable and what type of consequences an action may cause. So the court also said that first a norm cannot be law, and then the law that is formulated, it must be formulated in such a way that it is sufficiently precise, okay, to enable it to tell the citizens how they have to conduct themselves. Okay, so that it should not be vague. It should not be vague, okay, or uncertain as was claimed by the applicant. Okay, so the law cannot be so vague and uncertain that the citizens are in confusion or it is ambiguous. Okay, it's not clear. So a law has to be very clear and it should be sufficiently precise. It should be formulated in a way that it is sufficiently precise to enable the citizens to regulate their conduct, so that they can uh, in a given situation they can foresee the consequences of their action. Okay, suppose the law says today that you are not supposed to violate somebody's right by beating him, okay, by physically assaulting him. Okay, so this is a clear cut formulation of the law. Okay, so there is no ambiguity in this. So, in a given situation, if you are going to beat up a person, if you're going to thrash him, you will be violating the law. And then, in that case, you can reasonably foresee that if you do if you indulge in such kind of conduct, or if you do this act, you will be prosecuted as per the law because you have violated the law. So laws should be sufficiently precise, okay, to enable the citizens to regulate their conduct. Now, using this standard, the court held that the applicants were able to foresee, to a degree that was reasonable in the circumstances, the consequence of publication of the draft article. That means the when the publishers, means when the Sunday Times it published, you know, its article, or when it was writing that article was being written at that time, they could easily, the writer of that article, the editor, the people concerned, okay, uh, the Sunday Times, okay, it could reasonably foresee that this article will have such consequences, okay, that it will move, uh, you know, the it will move the it will form an opinion, okay, and it has the ability to move the opinions of the people. Okay, now therefore the court reached the conclusion that while it was, means the injunction that was granted, it was an interference with the applicant's right to freedom of expression, it was not an interference that was prescribed by law. Oh, sorry. While there was indeed an interference with the applicant's right to freedom of expression, it was an interference that was prescribed by law within the meaning of Article 10. Okay. So after this, the court analyzed that first whether the restrictions that were imposed it pursued a legitimate aim. We have already seen in the Handicide case that when we were dealing with Article 10 that the restriction it's not enough that it's prescribed by law, but then the other requirement is that it should pursue a legitimate aim. Okay, and it should be necessary within a democratic society. So both these requirements also have to be fulfilled. Now, with this regard, the court found that the court, in imposing the injunction, in granting the injunction, or imposing the restraint on the article, on the publication of the article, it had pursued a legitimate aim. Okay, the the legitimate aim was to restrict the interference. Okay, so that uh, the judiciary also it's not influenced in a manner that it can become biased or can have preconceived notions. Okay, and it can remain an objective judiciary. Okay, now on uh, the second thing that the court went on to analyze was that the second point that the court went on to analyze was that the court analyzed whether the interference, okay, whether it was necessary, okay, within a democratic society. Okay, so with this regard, with uh, the court, it reached to the conclusion that uh, this was not necessary to the court reached the conclusion that this was not necessary to maintain the values in a democratic society. Okay, now the court it said that the interference did not correspond to a social need sufficiently pressing to outweigh the public interest in freedom of expression within the meaning of the convention. Now, when we were doing the earlier case, we uh, saw that the court tries to balance. Okay, now it's like you have on one hand you have the restrictions that have been imposed, and on the other hand you have you know the interest of of preserving a democratic society. Okay, you have therefore if a restriction you know on one place you see what is the effect of the restriction. Okay, the restriction, and on the other hand you see whether it's necessary or not, and you outweigh. So if the social need, okay, for the restriction on the other hand, okay, the social need it outweighs the effect of the restriction, then it will be said that the said restriction is necessary. Okay, but if the effect of the restriction, okay, it is disproportionate, suppose it's disproportionate, okay, then it will, or it's it is more than it does not pursue its the aim for which it has been you know uh, for which it has been imposed, then what will happen is the court will reach to the conclusion that it's not necessary for a democratic society. Okay, so it sees both the effect of the restriction and whether it is necessary for the necessary within a democratic society. Okay. So regarding this only, the court told that the interference in this case, it did not correspond to a social need sufficiently pressing to outweigh the public interest in freedom of expression within the meaning of the convention. Therefore, it the court, it said that Article 10, uh, because this involved the press, so the court also, it told that the freedom of press, it commented on the importance of the press, and it told that the freedom of the press not only uh, involves the right of the press to inform the public, okay, but it also encompasses the right of the public to be properly informed. Okay, so the freedom of expression, it not only has the freedom of the press to inform the public, but it also encompasses the right of the public to be improperly informed. So this we already did, and we understand this very well because we did this in law and media classes. Okay, where we were discussing the role of press, okay, and the content of article 19, okay, which has article 19 of our constitution of India, okay, which deals with right to freedom of speech and expression. There also, under that article that talks about freedom of speech and expression, we have the right to know, okay, isn't it? So you can also make a comparison between how the European Court of Human Rights, okay, has dealt the freedom of expression, and how it has evolved the jurisprudence regarding the right of the public to be properly informed. And on the other hand, you can make analyze how the Supreme Court of India has evolved this right to right of the public to to be informed under the Indian Constitution. Okay, so the European Court of Human Rights, it told that Article 10 guarantees not only the freedom of the press to inform the public, but also the right of the public to be properly informed. And with regard to the facts of this case, it told that in the present case, the families of numerous victims of the tragedy, okay, who were unaware of the legal difficulties involved, had a vital interest in knowing all the underlying facts and various possible solutions. So, if you impose a restraint on the press to talk about these issues, okay, or to publish about these issues, then they could be these people who had a vital interest in knowing the facts of the case and the possible various possible solutions, okay, of their case or in their case, then they could be deprived of this information which was crucially important for them. Okay, and they could be deprived of this information only if it appeared absolutely certain that its diffusion would have presented a threat to the authority of the judiciary. Okay, that means the information that was, important for the applicants. Okay, if it would have undermined, the authority of the judiciary in any way, then only it could have been refused. And of course, in this case, the court ultimately reached to the conclusion that this was not the case. Okay, the information that the publication of the article would not have undermined the authority of the judiciary, so it was uh, not necessary to withhold the information or to impose restraint on the publication. Now, therefore, the court concluded that the interference complained of did not correspond to a social need sufficiently pressing to outweigh the public interest in freedom of expression within the meaning of the convention. Okay. So therefore, any right means the, if we talk in uh, the present context, the right under Article 10, that means the right to freedom of expression. Okay, if there has to be an interference in that right, in the enjoyment of that right by the state, then there has to be a pressing social need. Okay, that will outweigh the need for enjoyment of that right. Okay, so if you have such a necessity, if you have such pressing social need that this right, the right to the freedom of expression, it needs to be curtailed or regulated or restrained, then only in that case only the right can be interfered with, the enjoyment of the right can be interfered. Otherwise it, it cannot be. Okay, otherwise it will be violating the mandate of the convention. So the court, it found that the reasons for the restraint imposed on the applicants was not sufficient under Article 10.2. Okay, and the restraint, it also proved not to be proportionate to the legitimate aim pursued. Okay, so although the earlier, please understand this, that it the restraint was, although it was pursuing the legitimate aim, the aim here was to preserve the authority of the court. Okay, and the not to interfere or to create a hindrance with the administration of justice. Okay, but it this restraint that was imposed in pursuance of that legitimate aim, okay, that was not proportionate. Okay, it was disproportionate, and it was also not necessary in a democratic society for maintaining the authority of the judiciary. So therefore the court held that the injunction or the restraint imposed on the publication of the article, it was violating Article 10 of the European Convention of Human Rights. Now the next case that we will see is Patton versus United Kingdom. Okay. This case concerned Article 2, that is right to life. Basically, Article 2. Okay. Uh, in this case, what happened was there was a married couple, okay, who were estranged, okay, and the wife was pregnant. Okay, so the husband, the wife wanted to have an abortion and was going for an abortion. She had been given the permission also for abortion, but the husband, he did not wanted the abortion. Okay, and therefore he argued that the fetus that his wife carried, that means the unborn child that his wife was carrying at a time, that unborn child also, that fetus also had the right to life. Okay, and the termination of the pregnancy would go against the Human Rights Act. Okay, this contention was not, of course, upheld in the domestic courts. Okay, after which the husband, that is Patton, he approached the European Commission. Okay, and the commission, it observed that the life of fetus is intimately connected with and cannot be regarded in isolation from the life of the pregnant woman. Okay, and it said that if Article 2, that means the right to life, okay, the if Article 2 were held to cover the fetus and its protection under this article were in the absence of any express limitation seen as absolute, an abortion would have to be considered as prohibited even where the continuance of the pregnancy would involve a serious risk to the life of the pregnant woman. Now, this would in effect mean that the unborn life of the fetus would be regarded as being of a higher value than the life of the pregnant woman. So, so the according to the court, the woman, the pregnant woman, okay, she has to be given priority, and her decision has to be given priority. Okay, so because she is the one who is going through that process, okay, and it's her body, okay, so she has the first right to choose whether she wants to have the child or not, or whether she wants to have the abortion. Okay, so taking this argument that the fetus also has the right to life, her life, okay, and her choice cannot be put into jeopardy, okay, and risk, and therefore it's ultimately the decision of the woman, okay, whether to have an abortion or whether to bring the child into this world. So the court, it held that the right to life in Article 2 of the European Convention on Human Rights does not extend to the unborn. Now, the Commission, it also said, found that the right to respect for one's private life guaranteed by Article is 8. Okay, that talks about, I think, married life. Okay, is not so broad as to extend to a father's application about his wife's decision to obtain an abortion. Now, apart from this argument that the fetus also has the right to life, okay, and it has to be considered, the husband, he also argued that he is the father of that unborn child, and therefore if any decision has to be taken, the wife has to consult him, she has to inform him, consult him, and then only she can take, okay, any decision. So without his authorization it cannot be, or without his consent. So this was also negated by the commission, okay, and it told that the respect for one's private life. It Article 8 mentions that both of them should have equal right. Okay, so it told that it cannot be stretched to so much. It cannot be interpreted in such manner so as to stretch it. The meaning of the article. It cannot be stretched so much as to include uh, that the father has to be informed or consulted, etc., about the wife's decision to obtain an abortion. Okay, so the that means Article 8, it does not give him procedural rights in any sense. Now, the third case that we come to now is Rafah Partisi and others versus Turkey. Now, in this case, what happened was the Rafa Partisi was it translates into the welfare party. Okay, it was a political party in Turkey. Okay, and its members, okay, they were the applicants, uh, and the others who were there. Okay, they were the chairman and two vice chairman. Okay, of the welfare party, that is Rafa Partisi. Okay, and they were also members of parliament. Now, in May 1997, the Principal State Council, okay, he had applied to the Constitutional Court for the dissolution of the party. on the ground that it was a center of activities contrary to the principles of secularism. Now, for to prove this, he had referred to certain acts and statements of certain leaders and members of the party, and he told that the party had, called to engage in a holy war, that is jihad, and it had also called for introducing religious laws, that is, making uh, Turkey a theocratic state and introducing Islamic law into Turkey. Okay, Turkey was, and has a constitutional structure of secularism. Means it has secularism as its constitutional structure. Okay, now uh, this was supposed to, by the Rafa Partisi party. They, according to them, this they wanted to bring a change in this structure. Okay, and instead of secularism, they wanted to have Islamic law to govern Turkey. Now, taking the case, the court it held that the introduction of a separate legal system, okay, and the introduction institution of theocracy, that means the Sharia legal system and the institution of theocracy. Only theocracy means a state that is based on religion. Okay, one state only, uh, one religion only is permitted in that is country. Basically, okay, one religion governs the polity of that country, and it has a major role to play. The state is based on religious religious notions, and the religion plays a major force in that. It's the religious norms and values that decide how the state runs. Okay, so you know it also, Rafa Patisi also in certain, the in certain of its addresses, the members of that party, they told that they would, if need be, resort to violence also to introduce this and to bring this change, to introduce this legal system and to bring this change. Now, this was told by the court as being against the constitutional principle of secularism. Okay, and therefore, the court decided to terminate the applicants' mandates as members of parliament. Okay. And it also banned them from founding or joining any other political party for 5 years. Now, against this decision, the Rafa Patisi party, or the Welfare Party and its members, they approached the European Court of Human Rights, okay, alleging that this decision infringes their right under Article 11 of the Convention, that is freedom of association. Now, the European Court at first considered whether the restriction was as prescribed by law, which is the first thing that it has to see. Okay, while dealing with any kind of restriction, first it has to see whether it was prescribed by law. So the court, while taking this issue into consideration, reached the conclusion that it was uh, against the secular, against the principle of secularism, okay, and was unconstitutional. Okay, and the constitutional courts in Turkey had the sole jurisdiction to dissolve a party which was a center of such activity. So therefore, the court reached the conclusion that this was as prescribed by law. The restraint that was put, okay, it was prescribed by law. It also told that uh, you know, the members of the party, okay, the party in itself was a large political party and the members were well educated. Okay, they were politicians, seasoned politicians, and they were lawyers, etc. So they could also reasonably foresee the consequences of their actions. And you know coming to the point of legitimate aim. Okay, so we know that the any restriction first has to be prescribed by law, and then it also has to pursue a legitimate aim. So the court also reached the conclusion that the aim that was that was sought to be achieved by the dissolution of Rafa Partisi, or the welfare party, it was in consonance with the pursuance of legitimate aim. Okay, because the aim was to protect the national security and public safety, and prevention of disorder or crime, and protection of the rights and freedoms of others, by basically adhering to the principle of secularism. Because if secularism is not there, if a theocratic state is there, inevitably and essentially there will be discriminations, and discrimination based on the ground of religion, etc. And it will that discrimination will of course infringe and violate other people's rights and freedoms and liberty. So the dissolution of the political party, in this case it was in pursuance of a legitimate aim. Now the court further analyzed this was whether the for imposing the restriction there was a pressing social need. Okay, so of course the court, it reached the conclusion that there was a pressing social need, because the Reva party, turned out as the it had come out as the largest political party. Okay, and therefore, while its policies were already dangerous and in contravention with the rights and freedoms given in the convention. Okay, it coming out as the single largest party and coming close to form a government, the chances of its implementing those policies, okay, made that danger more tangible and more immediate. Okay, so therefore there was a pressing social need also. Okay, as to the requirement of proportionality, the court said that the Refa's other members of parliament, okay, they remained in office. Okay, and the prohibition that was imposed, it was only temporary. It was imposed for a period of 5 years. So the dissolution, the restriction cannot be said to be disproportionate also. Okay, so the European Court of Human Rights, it in conclusion, it upheld the Turkish Constitutional Court's dissolution of the Rafa Partisi, or the Welfare Party, for violating Turkey's principle of secularism, and it also held that Sharia is incompatible with the fundamental principles of democracy. Now we have finished with three cases today, and in the next session, I think two or three cases more are pending, so we will be taking up that case. Okay, so if you have any doubt or if you want any clarifications to be made, you can write to me. Okay, I'll be very happy to redress any doubts and any problems that you are facing. Okay, until then, I hope that you are studying wherever you are, and I'll be also giving you assignments on the topics. So kindly do that and submit that to me. Until then, we'll in the next session we'll continue with the case law, and we'll finish off this European Convention of Human Rights. Thank you.